Good morning, Your Honors. May it please the Court, my name is Michael Philippi. I'm Deputy County Counsel for Monterey County, and I represent the defendant and appellant, Ivan Rodriguez. We've asked the Court to look at the District Court's decision with regard to a decision on a motion for summary judgment. We're contending that the District Court erred in the analysis when it looked at the question of qualified immunity. The Court seemed to stop at the decision of saying, well, there's a dispute factually as to whether or not we can say as a matter of law there was excessive force, or there was an unreasonable length of detention, or there was a Fourth Amendment violation in search of the wallet. The next step in that analysis with regard to qualified immunity would have been to say, okay, we're going to give the plaintiff the benefit of the doubt on the questions with regard to fact, which is the standard for summary judgment review. But then we have to look at, would a reasonable peace officer say, I believe my actions fall within the law? To do that, you also have to look at whether or not the law is clearly defined.
Why wouldn't the answer here have been no to that question? I mean, there was no reported crime, certainly no crime of violence.
There was a 911 call of a suspicious person inside a house.
Suspicious person inside the house. That's not a crime.
No, it's not a crime, but...
I'm sorry, beside the house, right?
Well, the point is, an officer is going to respond to a 911 call. He gets some corroborating... Certainly respond to a 911 call. But the fact that somebody makes a 911 call doesn't enhance the facts in any way. The fact of the matter is, the caller saw nothing that looked like a crime. Just some guy outside the house, the way you and I might be around our houses, right? And then goes in. There's absolutely nothing like that. And then the officer approaches Mr. Aquino, and he does nothing suspicious. He does nothing illegal. There's no evidence of anything like that. And then the next thing he knows, Mr. Aquino's on the ground losing consciousness. I don't know why you're here. Why are you appealing this case? I am a little baffled. Because the district court didn't complete the analysis with regard to...
Well, go ahead, complete it. I just don't see what there is to complete. I mean, officers shouldn't be violently attacking people outside their own houses and then sticking them... I'm talking.
Yes, sir.
I mean, do you want to just waste your time?
No, I don't want to waste my time.
Well, that's what you're doing.
We're here on de novo review, so it doesn't really matter what the district court said exactly. What matters is whether your clients are actually entitled to qualified immunity. And so far, you haven't told us why they are.
All right.
I mean, you've spent a lot of time talking, but you really haven't come up with...
The officer's given the benefit of the doubt. If a reasonable officer can believe his or her actions fall within the law, even if they're mistaken.
We do know what the law is. What you haven't told us what it was that the reasonable officer saw that would have justified knocking down Mr. Aquino and then locking him up in a police car for half an hour. What is it? I mean, start talking.
All right.
You're already halfway through your argument. You haven't come up with a single thing.
He responds to a 911 call. He's directed to the house, which was also identified in the 911 call. He goes on the property. As he's determining whether or not there's any signs of forced entry, someone inside the house closes the blinds. He decides at that point he's at risk. He's going to withdraw. Someone from the house comes out that matches the 911 call individual and
asks if he needs help, right? I mean, what criminal comes out and asks the police what they need?
Well, if you're trying to divert the attention of the officers so your compatriots can get away or a little child can be slaughtered in the back bedroom, that's a perfectly good way to defer that person's attention away from what's happening.
Well, why isn't the thing to do, if you really think that there are criminals inside and there's crime going on, why wouldn't a reasonable officer call for backup?
Backup was on the way.
And wait for backup? To deal with the situation rather than physically attacking a homeowner outside of his own home.
Well, he was
if
retreating.
it happened to you, would you feel this was justified?
If it happened to me, I would have given him my identification.
Well,
the officer-
he did give identification.
No, the officer or the individual pulled out a wallet and pulled out a card and held out a card that said, "This is my identification." When the officer tried to inspect that identification, he withdrew it. So under the totality of the circumstances,
I'm
the
sorry,
officers...
withdrawing the identification is a justification. I mean, that's not illegal. I mean, the officer can look at the ID in his hand, doesn't have to take it.
He wasn't given that opportunity.
So he could say, let me take it.
Well, he held out his hand implying, "Let me have a look at the ID," and instead the individual withdrew the ID. And under the totality of the circumstances, the officer at this point has reasonable
Says,
suspicion.
okay, I'm going to knock you down because you withdrew your ID.
Well, he was
I
told...
can't believe you're standing there making an argument.
I believe that he is entitled to qualified
And
immunity.
what justifies them putting him in the police car for half an hour?
He was in the police car for less than half an hour, but even if he was in the police car for half an hour, the courts have already determined...
I'm sorry, let's focus on that. He says half an hour.
Okay.
Okay, and you've said you give the plaintiff the benefit of doubt as to the facts, right?
As to the violation, yes.
Well, as to all facts. I mean, if there are disputed facts, we have to assume plaintiff's facts.
Okay.
So why are you arguing with me when I say half an hour, you say it was less than that? What is the significance of doing that?
Well, the courts have said, and there is a case directly on point where the court has said 25 minutes is not an excessive amount for a detention.
I
But
understand.
he says it was half an hour, so don't we have to give him the benefit of the facts at
All
this
right.
stage in the litigation?
There are other cases that even go farther than that say you can be put in a police car, you can be transported across town and presented for identification with somebody else
All right,
and then
but
transported
my
back.
question is, I said half an hour, and you disputed that. You must have had some reason for doing it, some justification. We have to accept, for purposes of this appeal, it's half an hour.
Okay.
Not okay. Yes or no?
Yes.
Okay, so why did you dispute this? Why when I said half an hour, did you think it was appropriate at this level, in this argument, to dispute the half an hour?
My apologies. There is.
I'm asking you why you did it.
I-
Why did you do it? What is the significance of it?
There is a CAD report, which is generated by an...
I'm sorry?
A CAD report. It's a radio transmission. It logs the radio transmissions from the point of the 911 call to the point that the entire situation is cleared, and that shows that it was less than half an hour. It shows that it was
So you want us
25
to
minutes.
dispute, you want us to...
No, that was my error, Your Honor, and I apologize. No, that was my error, Your Honor, and I apologize.
Counsel, I want to ask you about what the district court characterized on page 9 of the opinion, the extended physical seizure. And you didn't refer to it by name, but I know you know the case, the Gallagher's case.
Yes.
And the district court judge cited it several times in the opinion. And what I want to know is, do you think the district court judge didn't give proper weight to the Gallagher's case or misapplied it in some way?
I think the court didn't give it proper weight. I think that in that situation, you had an individual who, as I referred to, is stopped, transported across town for a lengthy period of time, is in handcuffs, was stopped at gunpoint, and was determined not to be the individual who was trying to break into the house, so was transported back to his vehicle, which took a substantially longer period of time, was a substantially more intrusive stop, and yet the court said that that's not a violation of the Fourth Amendment. And here we've got a situation where an officer responds to a 911 call. It's not his decision to make the stop. He responds to the 911 call. An individual that matches the description shows up out of the house. There's an exchange. He's told he's being detained, and then he resists the detention. At that point, it's no longer a detention. It's a resisting arrest situation. The officer then...
I'm sorry, why was he being detained? I lost track of that.
So that the officer could complete the investigation as to whether or not he was actually the renter of the home.
I'm sorry, this is after he knocked him down?
This was before they had the confrontation.
And what did he do that was inconsistent with being detained? I'm just losing track of the
I'm sorry, when you
narrative
say
here.
inconsistent.
He didn't walk away. He didn't walk away. He didn't. I'm just wondering, what is it that justified putting him in the police car? I mean, he says you're detained, okay. And does he do something that's inconsistent with being detained?
The officer wants to place him in handcuffs for his safety because his backup has not arrived at that point. the individual resists being handcuffed. And so at that point, he
That's
says...
a fact dispute too, isn't it? He says he just fell.
He says he was dragged to the ground. So if you
No, but I think he disputes that he resisted being handcuffed, doesn't he? I thought he did.
He said he was complying, yes.
Okay, so again, why are you doing this? Why are you arguing, after you concede, after you state that and you understand the legal framework, that we accept the plaintiff's facts, we have to accept the plaintiff's facts, why are you now arguing things on the other side that's inconsistent with that? Is that professionally appropriate? Is that being candid with the court?
I believe that the analysis for qualified immunity still requires the court to make a finding that says the officer was not reasonably justified in believing his actions.
But we have to
fell
accept the
within
facts
law.
on the ground as plaintiff alleges them. And plaintiff says, I complied. Why are you arguing he didn't comply? Why? How can you stand there
I'm not saying
as
he
an
didn't comply.
officer of the court? And I'm sorry?
I'm not saying he didn't comply.
But you just
said
did.
he
You just said
resisted
exactly that. You know, this is on tape.
Okay.
Okay, so you should go back and look at it, and I think you should have your supervisor look at this. You understand?
I do.
I'm directing you to, who's your supervisor?
Susan Blitch.
I couldn't hear you.
Susan Blitch.
Susan what?
Blitch, B-L-I-T-C-H.
Okay, you will ask her to watch this argument and see whether making the kind of argument you do is she thinks is appropriate.
Okay.
Okay? We'll hear from the other side.